back at my office, as well as the 8 staff, are focused on all things real estate, from enforcement of purchase agreements, drafting purchase agreements, lease agreements, exclusive listing agreements, exclusive buyer agency agreements, easements, to things maybe you don't see as frequently, land use issues, which we'll touch on a little bit today, riparian rights, construction, zoning, development, etc., and everywhere in between. I've been very fortunate to grow my business exclusively by referrals. And the vast majority of the referrals come from real estate professionals like yourselves. We also get them from surveyors, civil engineers, and other attorneys. I should mention that one of the attorneys at my office and 2 staff people are also involved in probate and estate planning, but the rest of us, it's all real estate. That's both residential and commercial and all aspects of it. So I thank you for the referrals I get, resource. You run a situation, your client runs into a situation, you want to discuss it, always go to your broker manager first. But assuming your broker manager gives you permission to call us, we are happy to take those calls. When you call in, please let the person know who you're speaking to. The urgency. I'm in a closing. I represent a buyer. This occupancy was supposed to be transferred at the closing table. The seller is saying they need another week. That's an emergency. Let the person on the phone know. They will get you on the phone with an attorney. We try to take all calls when we can, but we're in court, we're talking to other clients, we're presenting, etc. But if you have that kind of emergency, let the person know, and they will get someone on the phone. If it's not quite that sensitive, I need to talk to someone tonight before my listing appointment tomorrow, or I need to talk to someone by the end of the week, or my client's only available at 6 o'clock at night during the week. We will be able to accommodate you. Let the person who answers the phone, who will be a full-time employee of mine, let them know your situation, and we'll be happy to talk to you. People say, well, Rick, how much does that cost? To be clear, we are not charging somebody until they've agreed to be charged. Specifically, they've signed a retainer agreement. If somebody hasn't signed a retainer agreement, they're never going to get a bill. Now, I can't say, somebody might say, boy, all that work, Rick, that's a lot of money. That can happen in litigation. But I can tell you, nobody's ever received a bill and said, what is this about? I don't understand. It never, ever happens. Why? Because they have to sign a retainer agreement. So, quite honestly, sometimes we'll be in a consultation and I'll be explaining to somebody what I think, and I try to give my opinion based on the information provided, even without being retained. But someone will say, well, Rick, can you review just this document over here? It's a 65-page master deed and bylaws, and just let me know as part of the consultation. I'd say, well, that's something we charge for. And they say, well, charge for? What are you charging? I say, well, it'd be hourly. I give them estimates. They're like, well, I'm okay, Rick. I'm going to take a pass on that. No hard feelings at all. The point is, again, nobody will be charged unless they've agreed, which means they've signed a retainer agreement. All right, on to the presentation. And you'll let me know if we have questions, right?
Yep.
All right. We are talking about riparian rights. So I can't really speak to the people out in Zoom land, at least not call and response. But what does anyone in the room have a definition for riparian rights? What do you think of when you think of riparian rights? I heard water.
Lakes.
So a little bit. All right. Riparian rights. These are the rights that are afforded to a property owner that has property that abuts a natural body of water. Again, if you own property that abuts a natural body of water, you have riparian rights. Your riparian rights don't arise from a particular statute. They don't arise from a particular document. Michigan common law says you have riparian rights. What are those riparian rights? Those are the rights to use the surface water of the body of water that you abut. Putting a dock in, mooring a boat overnight, picnicking, fishing, swimming, frolicking, etc. Those are the rights. Now, this conversation, most of it will be geared towards inland lakes because, well, we're not that close to Great Lakes. We're not too far. I will touch on Great Lakes. I'm happy to answer questions about the Great Lakes if those questions come up, but the vast majority of our practice, at least as it relates to riparian rights, deal with inland lakes because I believe there's over 15,000 inland lakes in the state of Michigan. And quite honestly, they're all around us in our little area, being even metropolitan Detroit. Yes.
So here's a circumstance already presented up here. Don't know if it's the appropriate time, but it may set you up for something. One of the agents has a client with a property butting against or a significant size pond. One of his neighbors feels that because he can launch a duck boat into the water, he can hunt anywhere on the pond, even though the lot lines which cross the pond are known to both parties. Client's extremely bothered. What can you say in this particular instance? Is it time for that one yet?
No, but that is a great question. I might even like write that question to myself. But so I'm going to come back to it in just a moment,
All
whoever
right.
that wonderful author is. So first of all, riparian versus littoral. So riparian rights are those rights that go hand in hand with a property that abuts a river or stream. Littoral rights is the term used if your property abuts a body of water, like an inland lake or a Great Lake. I bring it up just because sometimes you'll hear the word littoral used. But I want to be clear, in the state of Michigan, specifically courts, but even the regular vernacular that we all use, everyone uses the word riparian rights to encompass both riparian and littoral rights. So I only bring it up in case somebody said, well, what do you think about the littoral rights of this? And you're like, littoral rights? I went to Rick's class. I don't even know what that is. He never mentioned it. So it is a term that used to be used. It still has validity, but you will never see it in any published opinion from a court. It's riparian rights if it has to do with those inherent rights for a piece of property that abuts any body of water. So let's go to our next slide. Great Lakes versus inland lakes and ponds. This is the question, which I'm going to come to at when I get down here to ponds. So first of all, Great Lakes. We will touch on all of these, but Great Lakes are different than a traditional inland lake in that Great Lakes, you own if you own, I should say, not that you own, but if your property abuts the ordinary high water mark, and we'll touch on what that means in a second, your property is riparian. Unlike an inland lake, the people that own property that abuts the Great Lakes, which is the ordinary high water mark, that's where your ownership ends. If you have a property that abuts an inland lake, you might, it depends on what a plat says, but you might own bottomlands, which is not unusual. In fact, it's more common if you own property that abuts an inland lake that you would own the bottomlands. But I want to be clear, your property is riparian if it abuts the water. And just to expand on what is abutting the water, it's abutting the ordinary high water mark, which I'll touch on in a second as to what that is, but it's a little bit self-explanatory. It's the point at which water, the elevation of the water meets the grade of your property. Great Lakes regulated by Army Corps of Engineers. There's a lot of dual representation where EGLE, which is Energy, Great Lakes and Environment, will regulate both the Great Lakes along with U.S. Army Corps of Engineers. Inland lakes, exclusive purview of engineering, Energy, Great Lakes and Environment. I keep switching the E's. EGLE, which is the predecessor to MDQ. Ponds, so I'm getting to this question, whoever wrote it. Ponds, as a general rule, are not regulated, not considered riparian in nature. What is important about this, well, there's many things I would say that are important about it, but let's touch on this question, and then I'm going to have the question repeated to me. And that is that a pond, generally speaking, does not offer riparian rights. What is the definition of a pond? Generally speaking, a pond is any body of water that is less than 5 acres. And let me clarify that a little bit more. Any pond that is less than 5 acres in size, which would include wetlands, so cattails, where you might not see open water. And the reason I use that definition is because in Michigan, EGLE, they regulate all bodies of water unless they are below 5 acres. Now, there's an additional definition because I don't want to be confusing here. EGLE will also regulate any wetlands that's within 500 feet of a body of water or river or stream. But for purposes of a pond, if it's less than 5 acres in size, it is unregulated. And generally speaking, a pond, and we're talking about at this point, because I haven't brought in the second component, we're talking about a naturally occurring pond. It's under 5 acres, it's unregulated. And if it's a pond, and we'll go to the question, there are no inherent riparian rights. Okay? So one of the things that I should have mentioned earlier when I said riparian rights is it provides access to the water. I mentioned dock, I mentioned boat, but it also provides access to the surface water. In fact, everyone in the state of Michigan has access to the surface water of all of our inland lakes through what's called the public trust doctrine. If you can get on the lake, you can navigate it. All right, but that's not the same as having riparian rights. Okay, but every person in the state of Michigan has these rights. On a pond, the public trust doctrine does not apply. That means that the general public does not have a right to use the surface water. So the question, as you might have to give it to me one more time, if you don't mind.
Yeah, so abutting a significant size pond, one of his neighbors feels that because he can launch a duck boat into the water, he can hunt anywhere on the pond, even though the lot lines which cross the pond are known to both parties. So I think a clarifying question is does this neighbor have, or does their property abut to the pond also? Rich, you might have to jump on and clarify a little bit for us on that.
Well, I'll see if he clarifies, but I'll answer it because this applies. And that is that if you own property that abuts a pond, you own to the property line. And I, in fact, had a case where a person owned approximately 95% of a pond, and another person owned like a 5% sliver. And the 5% sliver, they had a grandchild, and the grandchild would launch a boat, and the grandchild would fish in the pond. It was a couple acre pond. And the neighbor that owned the majority said, you can't do that. And the person said, what do you mean we can do that? Of course, he's just out there in a boat. What's the big deal? And the majority owner responded by putting a fence through the pond, right across the pond. Put in extra deep poles and literally right through the pond. And they called us, and unfortunately, we had to tell them that the majority owner had the right to do that, which was really unpleasant for our client because not only could their grandkid not fish, but aesthetically, it's pretty unpleasant to see the fence. Now, all these, as you might imagine, are fact specific. So, you know, I'm giving the answer because I don't want to just say, well, it depends, it depends. That's not very interesting, and it's not very helpful. But it always depends on the particular details. But as a general rule, in the question posed, the person that owns the majority, they can enforce their rights up to their property line, which might be, you know, 3/4 of the pond. That's the property line. There is no public trust doctrine that applies to a pond. Now, this is all predicated on the definition of pond being less than 5 acres. The question actually alluded to a somewhat significant sized pond. So a 5+ acre pond, I would call it a pond. But for purposes of regulations, I would say, generally speaking, riparian rights would be afforded. So again, that threshold of the 5 acres would be an important characteristic. Someone says, well, how do I know what the acreage is, Rick? And I'd say, well, you're going to need a survey. You know, and there are, just to be clear, there are companies out there that will do estimates based on satellite. That is not the same as a traditional survey, but it might give someone a good idea of, hey, is this worth fighting about? Because an aerial or a satellite survey says it's 7 acres. Yeah, it's not going to be perfect, but it's close enough. But if there's more,
just said that they do abut to it also, but you answered right along with it then with that one.
Yeah.
So,
all right. Oh, there. You're thinking? All right, perfect. All right, ordinary high water mark. I touched on this earlier. There are 2 different ordinary high water marks. There is the set ordinary high water mark, and then there is the natural high water mark. For instance, on the Great Lakes, every year there is a set high water mark, and it fluctuates, and it can fluctuate significantly. The natural high water mark is what's Mother Nature actually doing. So they can be different. The Great Lakes, the ordinary high water mark, if someone's curious to find out, is kept at the International Great Lakes Datum by Eagle. So go to the Eagle website, find the ordinary is. There was some concern about property that someone was looking and to see what actually was riparian in nature. Inland lakes, it always goes by the natural ordinary high water mark. The drain commissioner for Oakland County, as an example, keeps the ordinary high water mark for those lakes that are dam controlled, which many of them are. The thing that I would tell you about the ordinary high water mark is that water moves, as we probably have all seen. It goes up and down. Even in the dam controlled lakes, it still moves. And what's important to know is just because the ordinary high water mark moves does not all of a sudden make a property non-riparian in nature. I don't want to minimize the issue, but the fact that your property goes to here and then the water recedes to here, a foot away, does not mean your property is not riparian. In fact, quite honestly, it's generally just the opposite. If your property is riparian in nature, it generally remains riparian in nature, even if the ordinary high water mark fluctuates. Or not even if, it does fluctuate, but even when it fluctuates to the point where potentially your property ends and there's some space of upland before you get to the ordinary high water mark. The general principle, and I don't think it's important that we touch on it in any great detail, but I will want to mention, is called accretion. And accretion says that if your property is riparian in nature and water recedes, creating new upland, that new upland is assumed to be part of the property that was riparian before the new upland occurred. It's not 100%, but it is a very, it's a good rule to follow, because in most situations, that is in fact the case. So again, I wouldn't want people to be overly concerned about where the ordinary high water mark is or isn't relative to their property if it's fluctuating. That is not the same as I bought a property and the water's 50 feet away, and Rick talked about this accretion thing. I don't know what that is, but it sounds like 50 feet's accreted to me. As a general rule, that would not be the case. Riparian rights versus water rights, I don't think it's that important to touch on. Water rights are the ability to use the water, so to irrigate crops, to sprinkle your property, drinking water, etc. We're focused on riparian rights, which generally are recreational rights. And that's, to me, what creates all the value. In fact, when I make this presentation, I say, it's my opinion, and I'm always looking for feedback, that if you, and we're in Oakland County, so I'll speak about Oakland County, but if you're in Oakland County and you have a property that allows you to put a dock and a boat on water, hopefully that's not me, put a dock and boat on water, and again, your property isn't on water, but you have this right. I believe it makes a property worth a minimum on any lake in our entire county, at least $100,000 more. And on some lakes, I've been told that it might add up to $500,000 of value to have that deeded right to a dock. I don't know if people have any feedback, but I'm always interested in if people are like, oh, you're too low, you're too high, Rick, that's not so. So if you, and you don't have to give it right now, but if you have, yes. I agree. The floodplain is the buildable area that's important with a riparian property. And because that's going to establish where your setbacks are, because you're always going to have setbacks from your floodplain.
Excuse me, Rick, Rick, can you say what you're agreeing to? I don't know what the person said.
Oh, the question.
Sure.
Yeah.
So the question was, floodplains, specifically where the floodplain is a very important criteria or concern for riparian property. Gentleman said that. And the answer is yes, it's very important, because the floodplain will establish where you can build, and there are also going to be setbacks from the floodplain, which will further shrink what is referred to as your building envelope. So when you have a property surveyed, it's 100 by 150. Your building envelope is the setbacks put onto that lot. So if you have 10-foot side yard setbacks, 30-foot front yard, 25 rear yard. That creates your building envelope. Well, if you have floodplains that encroach on the lot itself, that is going to shrink down your building envelope, which is the area that you are permitted to actually erect a structure in. So yes, floodplains are an important concern.
So here's another one, Rick, that the dam breaks. So we talk about Midland or what happened in Holly to where they knocked the dam out. What did everybody just gain more land? How does that work?
So I'm glad you brought that up, Darwin. One thing I haven't touched on yet, and this is a good time to do that, and that is that I have repetitively said riparian rights are the rights that a property has if it abuts a natural body of water. What if it's not a natural body of water? Like the dam, that the rivers that are dammed up to create the lakes, the 4 lakes that were lost in mid-Michigan. If your property abuts a man-made body of water, you do not have riparian rights as a result of Michigan common law. Okay? You do not have riparian rights as a result of Michigan common law. However, the vast majority, in fact, I would say I've literally never run across it yet. If you have property that abuts a man-made body of water, you look to the documents themselves, which we'll touch on, but you look to the documents themselves to determine the level of use that is permitted. I have yet to see this, but it is possible with a man-made body of water that the abutting property does not have riparian rights. That to me defies logic, because as a developer, which I was a developer, I worked for developers for many years as in-house counsel, the whole idea is to make money. And the idea that you would somehow restrict someone's use of a body of water makes no sense. And so anyone developing these sort of situations, which now would be very hard to do, but even existing properties, like there's one in Green Oak Township where they flooded a rock quarry, which has probably now been 20 years. You are doing that to create more value in the property. And so the idea that you would strip away that value makes no sense to me. But as we'll touch on in a little bit, you always want to review the documents. And I'll say it now, I'll probably say it again. When I say you, I'm of the opinion that a real estate professional should not be reviewing the documents that I think are important for a riparian property to determine the extent of use. Not because you're not capable. There are many, many realtors who know this stuff forwards and backwards. But what I'm concerned about is that one could allege, that being a buyer, let's say, that is engaging in the unauthorized practice of law. And so much like you don't survey property, you don't conduct inspections, but you're there to explain, here's the value of the inspection, here's what we're looking at. You know, maybe we'll talk about the report. You know, here's the survey, here's the survey issue. In other words, the quarterback of the transaction. But it's my opinion that you do not want to engage in analyzing a property to determine what riparian rights, if any, exist. I'm guessing also your policies and procedures manual might preclude you from doing it. And again, I acknowledge that there are many real estate professionals that understand this, but I get these calls at my office, and some people may know, may not know. We will never pursue a claim against a licensee if they're acting in their capacity as a licensee. Said more plainly, we don't sue agents and brokers, ever. But we get the calls regularly. And the call will be something like, well, you know, my agent should have told me that, and this is not just about riparian rights, but this is about anything. We used to get the call when the market was ridiculously on fire. My agent should have told me to have an inspection. And, you know, during COVID, I'm giving an example, and we'd say, well, you know, I don't know what the dialogue was. You know, we don't sue agents, but I'm willing to listen for a moment. Well, I told my agent I shouldn't have an inspection because that made, if we didn't have an inspection contingency, then we're more likely to have our offer accepted. Okay. And so we did that, and the agent wasn't too keen on that, but we did that anyways. And then we bought this property, Rick, and now we have all these problems. And I'd say, okay, I thought you were calling because you said you had a complaint about your agent. Yes, my agent should have talked me out of not having an inspection. And sometimes I'll know the agent, and I'll say, I think to myself, I don't say it, but I'm like, there's no way the agent said, oh yeah, you definitely don't want an inspection. That just didn't happen like that. And my point is that people oftentimes will have a memory of convenience. They remember it the way they want to. Or they go to an attorney who says, well, why did you buy this house without an inspection? And they say, well, I saw on the internet, it made sense, and we thought it was a good idea, so we did it. And the attorney's like, well, are you sure someone didn't tell you? And the person's like, well, no, I just saw it on the internet. You sure your agent didn't tell you that it'd be a good idea to make an offer without an inspection contingency? And then the buyer says, yeah, actually, I think that's the way it happened. The attorney's like, you sure that's the way it happened? The person's like, that's exactly what happened. So again, I'm not here to badmouth attorneys, but people have a memory of convenience when it's convenient. And so engaging in the actual analysis of a particular right, I think that can be concerning. It can put you in a compromised position. I'll tell you the one that's most common that I hear about is, so, well, Rick, I had this property under contract, and forget me from the equation. It's a customer and an agent talking. So, well, I really love this property. You get to have a boat, and it's, the beach is 300 feet away, and I get to have a dock, or I get to put my boat at the dock. I get to moor it overnight. This is fantastic. And I want this house. I really, really, really want this house. And the agent says, well, okay, well, you should investigate. And some investigation is done. Seller or their agent says, well, there's nothing actually in writing that you're allowed to have a boat with a dock. However, my seller has had this boat at that dock for 20 years. In fact, my seller bought the dock from their seller, who had it for 15 years. So for 35 years, this is what's been happening on this lake. No problem whatsoever. And what happens in these situations is that if it's not in writing, and I think people out in the audience know, not in real estate, it's not enforceable. Buyer says, but you don't understand. This property is perfect for me. I want this property. I'm sure it's going to be okay. And the agent says, well, look, I'm not here to render a legal opinion, but it doesn't say you get to do this. So I'm, I don't know what else to say, but it doesn't say that. And then the person buys. And what's important to know is, in my scenario, the person that buys doesn't have any more rights than the person that sold them or the person that sold to them, because somebody's doing something that they're not necessarily permitted to do. And what is very, very important, I think, is when somebody's going to buy property, they need to do the investigation that is acceptable to them. And I don't want an agent to be caught up in somebody wanting something to be true. And this is, I'm using boats, but someone says, well, I want to put a pole barn in. I want to put a detached garage in. I want to put a deck in. I want to put a second floor in. I want a pool. I want whatever I want. And the fact that they say, well, down the street they have a pool, and over there they have a pole barn, doesn't make it so. And the same thing applies with riparian rights. If it's not in writing, generally speaking, those rights do not exist.
Rick, is there any quick update to what's happened in Midland?
So there is an assessment going around. The assessment for the Four Lakes, what's it called? The Four Lakes Council? I'm trying to remember what it's called. They are rebuilding the dams. They're incredibly expensive. The company that was liable for the dams went bankrupt. They have no money. And the assessments are huge, but I would say, and I'm guesstimating on the number. We have a client that we're in a lawsuit about, and that issue's come up. He has a property, but for a typical lot, I think it's almost $75,000. Yeah, and so, but if you own a lakefront property, you're like, I guess I'm paying $75,000 because I can't not have a lake. Maybe I can sell it to somebody. And I would actually say I'm not part of Four Lakes Council, the government. I'm not here to do any of that, but I would actually say that that's better, because if you're a buyer, you're like, okay, here's my math. The price is X plus 75,000. Now I'm going to make my offer, but I know at least what it takes, and the lake is coming back, but it's going to be years. I think the first dam is not intended to be constructed, I think completed in 27, I think. I mean, this is a many more multi-year ordeal. I mean, to me, it's terrible. If you lakefront home, you're losing years and years that you're never getting back. Even if someone says, well, the value will be restored. Like, yeah, but what about all the value that was supposed to occur, all my enjoyment during that time? And of course, if you wanted to sell, I mean, it's an unusual situation, I will say that, because the dam was in private hands, which is unusual. Most dams are municipally controlled. So I can't say a catastrophe can't happen, but it can. But this is an unusual situation. All right. We can skip this. I talked about riparian rights. All right. The most important question I get asked, and how am I doing on timing, by the way?
You are, yeah, 12:41.
Oh, okay, perfect. So the question I get asked the most is, if I have riparian property, may I install a dock? And the answer is yes, with some caveats. What's my yes with caveats? So if you own a single family property with a single family home used for single family purposes, and the dock is seasonal or temporary, meaning it comes out in the winter, goes back in the spring, a permit is not required by Eagle. And no municipality I've ever run across has attempted to require permits. And quite honestly, I don't think a municipality has the standing to do so. I believe it's the strict purview of Eagle. So the answer to the question is no. Now, change any of those facts. It's a single family lot without a house. It's a single family house that's not used as a single family house. You know, it's multi-tenanted inside. The dock's permanent, etc. Any of those changes could change the answer as to whether you need a permit or not. The fact that you need a permit doesn't mean you necessarily can't get a permit. I'm not saying that. I'm just saying you might need a permit. The next question is, may I moor a boat? And the answer is yes. May I moor a boat overnight? The answer is also yes. To me, the ability to moor a boat overnight is what creates all the value. The dock is a means to get to the boat. The boat is everything. If I can't moor a boat overnight, I'm not saying the lake doesn't have value, but it goes down significantly as to the value associated with a particular piece of property. Question is, well, what's overnight, Rick? And that might sound like kind of a dumb question, but in Michigan, we have a definition. Overnight is from midnight to sunup. So 12 midnight to sunup, whenever sunup is. This question is something that comes up when people talk about, well, see, Rick, you said there's this public trust doctrine, and people can go across the surface of the water. So if there's a public launch or the friend lets them on, they can go anywhere they want. And then I got these bass fishermen, and I wake up in the morning, and they're literally 6 inches off the shoreline, 6 inches from the ordinary high water mark. And they stay there all day. They brought food. I don't know what they're doing about the bathroom, but they're there all day long till 11 at night. And the answer is, or the question is, Rick, can they do that? They're bothering me. I mean, they're right there, Rick. The answer is yes. The public trust doctrine allows people to temporarily moor, which is not overnight mooring, allows them to temporarily moor their boat. So for those of you who have ever seen the sandbar at Cass Lake, at Cass Lake, there's a sandbar off of Cass Lake Road, and on a really warm Saturday or Sunday, there might be 500 boats at the sandbar. An incredible amount. You literally have to hand walk your boat through it to navigate. You cannot drive at all. You cannot do it under power. The only caveat is that you cannot, as somebody who's temporarily mooring, you cannot prevent the riparian owner from getting to navigable water. So if your lot's 50 feet wide and the bass fishermen are taking up 20 feet, as a general rule, that doesn't prevent you from getting to the water. But if they were parked in such a way that prevented you from getting to the water, reasonably getting to the water, at that point, they are violating Michigan law. It's not criminal, but a citation would be written. Obviously, I would suggest you just explain to them, hey, Can you move so I can get in and out? But they have the right to be there. Navigable water is also something important to talk about with respect to a dock. We have had several instances where there's been issues arise from the length of a dock. How far can a dock be installed into the water? And the answer is it can be installed all the way until you get to navigable water. What is navigable water? As a general rule, if you want to be safe about it, 4 feet and above is navigable water. Navigable water just means I could drive a boat through it. Anything less than 4 feet is considered unnavigable water. And you say, but Rick, I have a pontoon boat. I can go in 24 inches. I understand that's true. But for purposes of a dock may not extend into navigable water. So what is navigable water again? 4 feet and above. And so we run into instances, as an example, one of the cases that hopefully we'll get to, dock on Walled Lake, 135 feet into the water. At 135 feet, it was 42 inches deep. Just has some shallow parts of the lake. Atlas Township, I believe it's Atlas Township in Lakeville Lake, they tried to adopt an ordinance that said a dock can't be any more than 35 feet long. We were able to fight that and defeat that because there are instances, areas of the lake that were shallow and had to go out 50 feet before you could get to navigable water. So these things happen, but generally speaking, it's to navigable water. All right. Limitations, restrictions, and responsibilities. So these are the things that I would look at if I had, riparian property, or I was looking at riparian property. These are the 5 things that I would tell my client to look at or hire somebody who's knowledgeable about it to evaluate it. 1, look at EGLE, Environment, Great Lakes, and Energy. EGLE is online. Determine if there's ever been any permits pulled. Probably not, if you're looking at a single-family property. Has there ever been any reports or incidences? You know, someone tried to put in a beach, someone tried to take out wetlands. Generally, there's not going to be something, but this is sort of like a belt and suspenders. I would check just in case. Because if you buy a property, and this applies to not just here, but to many different facets. So you buy a property and someone put a beach in illegally, you're the property owner, you're responsible. It'd be just like if you bought a property where somebody did a fix and flip and they didn't get a permit, but they did work that requires a permit. Person that's responsible is the current owner. You're like, no, you don't understand. I bought it from, Rick Linnell, and he said, that all permits that were needed, he obtained that were necessary. And the municipality says, well, I don't know what Rick Linnell says, but what I'm telling you is you're the owner. You have work that was done without a permit. You must apply for an after-the-fact permit and it must be inspected. I don't know if you guys have run across that, but it's the same principle here. If you've done something, you don't get to say, well, I bought it this way. It doesn't work. So I would check EGLE. I would also check the local municipalities. Some local municipalities, West Bloomfield comes to mind. They will have ordinances, zoning ordinances, that govern the use of the lake. They have ordinances regarding where a dock should be relative to the side yard, that it should be centered. They have ordinances about docks at parks, community lots. So a subdivision has a community park lot, they have restrictions about that. So I would check with the municipality to see if they have any restrictions. Novi has restrictions that I can think of. And they may not impact the buyer. The buyer might say, well, that's of no consequence, or maybe I even think that's a good thing. But you want to know. Next, deed restrictions. It's not frequent that you'll find any particular language regarding riparian rights usage in a deed, but I would check the deed. Occasionally you will see language in a deed, especially in the older platted subdivisions. In Michigan, you probably are aware, we have 2 ways of splitting property. We have the Condominium Act and we have the Plat Act, P-L-A-T. The Plat Act goes through Lansing. The Condominium Act is administered at a county level. Developers prefer the Condominium Act as a general rule because it's a little bit easier to deal with in the sense that and this is my opinion as a former developer, that the counties are a little more interested in the development and will scale up if a particular county has a lot of things going on. They'll scale up their manpower so they can respond more quickly. There's nothing wrong with the Plat Act. There's nothing wrong with going to Lansing, but the Plat office is, it doesn't scale up, in my opinion, so that they can be as responsive. It's a little bit longer turnaround times when you make an application, they make comments, you get it back. And so you see the Condominium Act used more often. The point of bringing it up is that the Condominium Act didn't start getting used. I think this Condominium Act is from 77, I think. And you may be aware that the Condominium Act in the 80s started being used for site condominiums. You've heard the term site condominium? Yeah. So a site condominium is analogous to a platted sub. It's a single, even though the word condominium is in there, it's sometimes confusing. It effectively operates like a subdivision. In a condominium, you have a master deed and bylaws that are the rules. In a platted subdivision, you have covenants, conditions, and restrictions. Most lakefront property was created from a plat. Why? Because the Condo Act wasn't used back then. It didn't exist. So most of the times you have a plat that you are reviewing. And some of the old plats, the restrictions are very scant, and sometimes you will find some restrictions actually placed in the deed. More often than not, you will find them in the covenants, conditions, and restrictions, and or the master deed and bylaws. These are the rules for the property. And this will tell you if there are any restrictions that govern a particular property. I would look at this regardless. If it's lakefront property, I would look at all these things. If it's a property that just has rights to use, like a park, which is the more common scenario, I would definitely look at this. Because this this will state, sometimes not always so clearly, but this will state the extent that a park can be used. So you have a platted subdivision, it's got 100 lots, 20 are on the water, 80 are off the water. There are 4 parks that people get to use. What is the extent that you get to use the park? And as we talked about earlier, it makes a huge difference between I get to go to the park and have a picnic versus I get to go to the park and park my boat for the entire season at the dock and everywhere in between. So definitely you want to take a look at these restrictions to determine what is the extent of use that's permissible. The one thing I don't have on here, which isn't so common, but I would check, is a lake board. Lake boards are typically established, well, first of all, they're not that common, but they're typically established for weed control. That's the main driver, so that there's a cohesive effort by all lakefront owners to do weed control. You will also see sometimes some truncated hours of operation. So you're allowed to make a wake from sun up to sundown. You'll see some lakes where they will truncate that or shrink that down. Sometimes the lake board will control whether there's a water ski course or not. I'm not going to say that it might influence the horsepower. Not influence. It might state a maximum horsepower. It might state they have to be electric motors. It might state, I don't know what it states. I would, to me, if you're buying lakefront property or you have lakefront property, that's a consideration. Is it the most important? Maybe not, but that is definitely something that I would look at. All right. The cases. We're doing well for time?
54.
Oh, all right. All right. Well, let me make it quick. So Gun Lake. Gun Lake is a fancy lake on the west side of the state between Kalamazoo and Grand Rapids. I'd heard of it. That's about as much as I could say until I got this case. And I found out it's really fancy. And in my explanation, you'll hear why I think it's so fancy. So our clients inherit a property. The property is a manufactured home. And it was manufactured at approximately 1972. And it was set on a piece of land very close to the lake, but not on the lake. And the property had a 10-foot easement to the lake. So our clients, husband and wife, it was the wife's parents, and they bought it in 72. And the parents passed away, it was approximately 2020. And so the wife and her husband inherited this property. They lived in North Carolina, so they couldn't use it. And this was always been used as a vacation home. And throughout, from 1972 until the current, there was always a dock, and the owners moored a boat at that dock. Upon the passing of the couple, the adjacent homeowner who was on the lake that the easement was over. So when you have an easement, any kind of easement, you have the servient property. That's the property that the easement burdens. And then you have the dominant property. That's the person that benefits or gets to use the easement. So the servient owner was on the lake, had a magnificent house. And the servient owner came to my clients and said, one more step. One more fact. My clients started to market the property. They lived in North Carolina. They didn't have the ability to really maintain it. They loved it, but it was like a 1 week a year kind of thing. So they wanted to sell it. The property went up for sale, and the servient owner kept putting signs on the easement. No dock, no boats, walking only. And the dock and the boat was there. Put up these signs. Well, as you guys can imagine, that's not very helpful when you're trying to sell a property. So my clients came into town to talk to this very mature person, old person, to be clear, and said, well, I don't understand. Why are you putting those signs up? Like you're hurting our ability to sell it. So, well, you didn't know this, but I had an agreement with your dad. And I let your dad put a dock and a boat in all these years. Now, what I would tell you is that you've heard of adverse possession. You might have heard of acquiescence. Those are two ways to gain ownership of someone else's property. Both of those theories, and there's a third, prescriptive easement. Any of those three theories requires that, I don't want to say it requires, but they are undone or nullified if permission is given. So someone's using your property. This is not just about riparian rights, it's about anything. Someone's using your property. In fact, I just had this conversation this morning with somebody at my office. They're using your property. If they use it for 15 years and a day, they might have a good case against you to gain ownership. I say might because there's more to it. But if it's 14 years, 11 months, 25 days, and you say, and this was a shed that we talked about this morning, and you say to the person, it's okay if you put your shed there. I'm good with that. If that happens, you literally wipe out their entire adverse possession claim. And that's what this gentleman was trying to do. So, well, I let your dad do that for 50 years with your mom. And because I let them do it, you could never accrue the necessary time to make an adverse possession claim or prescriptive easement claim. Now, some people will say, and have had say, well, but Rick, what about they're grandfathered in? I mean, don't you, if you do something long enough, aren't you grandfathered in? What does grandfathered in mean? It means that you have a pre-existing non-conforming use. What does that mean in plain English? You were permitted to do something. There was no zoning ordinance that said you couldn't. Then a zoning ordinance was adopted that said you can't do it, but you continue to do it. And as long as you continue to do it, you get to do it in perpetuity. Here, the grandfathered use means you were allowed to use it at one time a certain way. The argument here is you were never allowed to use it. You were never allowed to put a dock in. You were never allowed to moor a boat overnight. And so this person who lived on the water, who had lots of money, said, yeah, that right doesn't exist. So the client calls us. Say, well, let me analyze the easement. Let me read it. Let me see what we can find out. And it's a one-page document. And in the one-page document is an easement for the private road. There's a little cul-de-sac that comes in that services my client's property, the difficult person's property, and a couple others. And then 2 paragraphs below that, it talks about the easement to the water's edge. And I read it quickly and I'm discouraged. It says, for the dock, it says to and from the lake. And then it says, which I don't even really quite pay attention in the very beginning, for the private road, it says ingress, egress, in and out. So I give it to my ace, if you will, Hunter Avis, who works in my office. He's an attorney, and we've been working together for 11 years. Hunter is one of the finest riparian attorneys in our entire state, land use attorney in our entire state. I am biased, but we have gone against many sophisticated attorneys and had some wonderful results, and in large part due to Hunter. So I said, Hunter, take a look at this document. Let's talk about it at the end of the day. And he calls me back about 20 minutes later, and it's 11 a.m. And I'm like, end of the day? What's the end of the day is not 11:30. He says, well, Rick, I think I found something. I said, okay, what'd you find? He says, well, did you read the paragraph about the the dock easement? I said, yeah, to and from the lake. Okay, did you read the language about the private road? And I said, well, not really. He's like, well, take a look at it. It's ingress, egress. I said, okay, I'm not really seeing anything. He said, well, Rick, what attorney do you know that would write a document and use two different words to describe the same exact thing? The other side's arguing that the easement to the water is just ingress, egress, into the lake, out of the lake. But that's not what the document says, Rick. It says to and from the lake. And notably, on the private road, it says ingress, egress. Rick, I did a word count. 184 words later, it uses a different term. No attorney does that, Rick. He's like, you wouldn't do that. And I'm like, well, you got a good point. You probably have all seen it. Attorneys use use defined terms over and over. They say the same thing. They say it like 20 times. You're like, enough, I heard it. I said, I think you might have something. What did he have? Well, Hunter recognized that in Michigan, let me take a step back before I say what Hunter recognized. In Michigan, if you have an easement, the courts will read an easement, and if it's only susceptible to one interpretation, in other words, it's clear what it says, that is the limits of the easement. So if it says you are allowed to go to the lake and back and nothing else, that's it. That's all you get to do. So it says, no, there's been a dock there for 50 years, Rick. There's been a boat there for 50 years as well. Court says, we believe you. It doesn't matter. It's strict interpretation. So you get to do what the easement says you get to do. If you can prove an ambiguity, which means it's susceptible to more than one interpretation, two people could read it and have two different thoughts. If you can establish an ambiguity, then the court has the right to look at extrinsic evidence. Extrinsic evidence, what is that? That is any evidence you can present that may have probative value to the court. The court determines if it has probative value. The court determines how much probative value. But the court then can look at the extrinsic evidence. And Hunter's position was, well, Rick, this is ambiguous. Look at these words. So we tell the client, look, we think we got something. We think we got a real argument here. Well, as you may know, you go to court where your property is located on the west side of the state. I don't make it over there very much for court, but we do good around the state a little bit, but certainly not enough where I'm saying hi to the court officers and the judge. Oh, hey, how's your kid? Like, well, I don't have that kind of relationship because we're not there that often. And one of the things you get worried about as an attorney sometimes is getting hometown, where all the other people know who's there, but you don't. I'm not saying it happens all the time, but sometimes it feels like it does. Well, it just so happens the other side hires an attorney that lives on the lake. So, and practices in this court all the time. So I make my argument in front of the judge, and just what I said, the difference between to and from versus ingress, egress, and the other side says, Your Honor, he's reading something into it that doesn't exist. They mean the exact same thing. They're synonyms. And he pulls out thesaurus and he shows, and the judge says, those are two different terms. Or they could be. I don't know. In either case, it's ambiguous. Now, here's the part that I like the best thing about this, or the best about this case. Okay, great. We got over hurdle one. Now you got to get to hurdle two. Provide extrinsic evidence that shows what the extent of the easement was. What was in the grantor's mind when they provided this easement? What I haven't told you is that the easement was granted by the seller of the property. You probably knew that, who owned all of the property. So before the person that contested it, there was a house there, but this person sold the land where the manufactured home was placed. They sold the home, the fancy home that this person now lived in. They sold all the homes at one time. They owned all the property. And in the purchase agreement, which was saved by the buyers and then passed along upon death to my clients, in the purchase agreement, the realtor wrote, in the additional remarks in 1972, the dock is included in the sale at no cost. And there was a bill of sale. And I said to the court, what are the chances that this person who owned the property where the manufactured home was and the fancy home on the water gave an easement that crossed the fancy home's property, included a dock, but the dock wasn't able to be installed? And of course, if you get a dock, that means boat gets moored overnight. Now, I didn't have any more than that, but the court said, yeah, that's exactly how I see it. And so the person was allowed to then, we had a court order that now said you get a dock, and you get a boat. The manufactured home, and no slight to manufactured homes, but it's from 1972. Those are not the best built homes. The property could barely see the water because it was landscape, etc. It had been listed for $450,000. The day after the judgment, the person who was the opposition bought it for $475,000 cash. That's what makes me think Gun Lake is really, really valuable. So, and in case it's not clear, we got over hurdle 1 as lawyers. I never get over hurdle number 2 without the realtor that precisely wrote in the contract, which somebody could have easily said, it's not even being charged. I don't need a bill of sale. Who cares? You know, there, it's going to be yours. Honestly, I could understand. I'd be like, I get it. It's don't have to. Somebody took the time to put that detail in, and that saved the case. Because otherwise, I would have just said it's ambiguous. Yay! And then, well, what was the like? I'm not. This is where I think. So it was the realtor that saved the day. So should I keep going my next case, or should I wrap it up? Oh,
Yeah, we should probably wrap.
All right.
As much
Well-
as I'd like to keep listening, I don't know if everybody else has got the opportunity.
well, I appreciate it. I'm happy to answer questions now or later. I'm happy to answer any real estate questions. I love real estate, and I love the opportunity that you guys have given me. So thank you very much.
Yeah. So guys, I throw it out. Rick does this, and he doesn't charge us. This is a pro bono thing, and the reason he's able to do this is because we can send him the business opportunities.
Absolutely.
So one of the things that I always say is anybody ever talks about needing an attorney, that we need to get somebody, excuse me, who specializes in real estate law, because it makes all the difference in the world. So just know that Rick's here. He's active in our business. He serves on North Oakland County Board of Realtors Board of Directors. So he's out there. He's with us. He knows us. He is an advocate for us and our clients and customers. So
Is he
with
taking
that,
a
guys, I'll
question?
just remind next week we're going to be having Jay Bellinger. We'll be in Northville, and we're talking about the update to what's coming with Moxie Rise. So this is going to be an even superior project to what Moxie is already. And of course, then if you've been hearing about Canva, that our brands are actually providing that to us.
Nice.
Learn all about it, what it is, and how you can use it in your business. And that will be on the 16th. And that's the last hot topic we'll have for the year. So everybody knows what to do. You go out, talk to people, and we'll see you soon. Have a good one.
Darwin,